The Resource Center for Human Rights and Civic Education has expressed worry over the continuous infringement of the rights of the original inhabitants of Abuja. The Executive Director of CHRICED, Comrade Dr. Ibrahim Zikirullahi, made this known during a roundtable discussion with stakeholders on how they can access justice and ensure the protection of their rights. Zikirullahi says that CHRICED will continue to place on the front burner the demands of the original inhabitants till they receive justice.
We must commend the FCT original inhabitants for continuing to walk the non-violent path in bringing attention to the issues that affect them. However, if the judiciary, which is often described as the common man's last hope, issues judgments that are not implemented, where does that leave those in search of justice? In the case of the FCT's original inhabitants, several judicial verdicts related to their rights have been simply ignored or put on hold. Affected citizens are wondering why this is the case and what is driving what appears to be a new pattern of selective obedience to court orders. Without preempting our learned resource persons perspective, let me state that this roundtable organized by CHRICED provides an opportunity to reflect on these issues of justice and rights protection, particularly through the experiences of the FCT original inhabitants. Despite the challenges, however, CHRICED is optimistic that the constructive perspective presented at this roundtable will put us on the path of finding a solution to these issues. It is also our hope that through this initiative, we will be able to address the FCT's original inhabitants' decades of marginalization, discrimination, and widespread neglect. As we have always pointed out, it is one of the many paradoxes of the Nigeria situation that the original inhabitants, whose lands were parceled out by decrees of 1976 to make room for Nigeria's capital, have been neglected, victimized, and treated as second-class citizens right in their ancestral homelands. We hope that this interaction will put us on the right track to effectively and constructively revising this unjust treatment of a people who have made enormous sacrifices for our country's unity and progress.
To give a legal backing to the decisions contained in the white paper issued on the Abuja Committee report, the Federal Capital Territory Decree Number 6 of 1976, Cap 503, Laws of the Federation of Nigeria 1990, now FCT Act, Cap F6, LFN 2004, was promulgated on 4th February 1976. Some of the provisions of the Act relating to the settlement and payment of compensation are reproduced hereunder, and it is very important. The aspects I have cited here are very important because they will show you eventually how the government itself failed or refused to implement them. Section 1, subsection 3 of the decree states, the area contained in the Capital Territory shall, as from the commencement of this act, cease to be a portion of the states concerned, and shall thenceforth be governed and administered by or under the control of the government of the Federation, to the exclusion of any other person or authority whatsoever, and the ownership of the lands comprised in the Federal Capital Territory shall likewise vest absolutely in the government of the Federation. It is important because this aspect, this portion of the subsection, was lifted and transferred into the Constitution as Section 272, subsection 2 of the present Constitution. No single case has been referred to a court in FCT since 1976 to determine what should be paid. No single case. And that section, Section 44, happens to be a fundamental human rights provision, which overrides any other provision of the Constitution that is non-fundamental. So Section 6, subsection 3, any person who claims any right or interest in any land comprised in the Federal Capital Territory shall submit in writing particulars of his claims to the Executive Secretary on or before the expiration of a period of 12 months from the date of commencement of the order made under Section 2 of this Act, or such longer period as the President may, either generally or in relation to any particular claim or claims, prescribed by notice published in the Federal Gazette. Till date, no order has been published. So by implication, there was no executive director to be presented claims. But you will see how a court of appeal judgment was used to show that FCT indigents were bastards. The ban on issue of customary rights of occupancy by FCT minister should be vacated forthwith to enable FCT area council chairmen to grant customary rights of occupancy in FCT. The federal government should stop forthwith the seizure of FCT indigenous farmlands and the demolition of their settlements.
The challenge of the original inhabitants is focused on two major rights. Both of them are personal, under the personal civil rights classification. The first is Section 42, which is the right against discrimination. The second is Section 43 and Section 44. 43 is the right to own property anywhere in Nigeria. Section 44 is the section that provides for the right and entitlement to the prompt payment of compensation in the event of compulsory acquisition. So, when it comes to Abuja original inhabitants, primarily, as long as human rights protection is concerned, these two rights are our major problems. Section 42, the right against self-discrimination, and Section 43 and 44, which is property rights.